Excellent. Well, welcome everybody. Welcome to the YouTube audience joining us tonight. This is terribly exciting.
Yeah, that was a lot easier than I thought. I was panicking. Oh my gosh, Russ. I was messaging Daphne. I was like, I'm going to mess this up. I'm going to crash our Zoom, crash our internet.
30 minutes ago, everything worked great.
I
2
know.
minutes out, you need to be authorized. What do you
Yeah.
think of all? I think Shanza should be responsible for all this. What do you think, Shanza?
Yeah.
Okay.
Didn't you run the summit last year?
I did, yes. But Russ, we weren't live on YouTube though.
I remember somebody ending early on day one.
Oh, my rookie mistakes.
That's okay. I did that once too. I think the 5 minute difference threw me off one day. Like if it was supposed to end at 35, I saw it was 30. I'm like, oh my gosh, we're over.
Well,
I don't know.
Shannon was the host, and then, or sorry, Shanza was the host, and then Shannon and I were going to wrap up, but she didn't transfer responsibilities, and everybody went dark. We
Yep.
got off early that night.
Sometimes it's a blessing in disguise, an extra couple minutes to grab a drink of water,
Yeah.
to, do things like that. So,
Hey, we don't have Joseph here tonight to talk about the Leafs. I guess we're gonna have to start talking about the Blue Jays next.
see, I'm not a baseball person. I don't know why. I just could never get into baseball. I like to go for like the hot dogs and the beer, but
There was a lot of team members at the game on the weekend for Mother's Day. I think Darla and a few others made it down.
This
yeah.
just reminds me of the meme of this girl. She's at the baseball game and she's on her Google and she's like, when does the game end? Have you seen them? Oh God.
It
Yeah.
can be a bit drawn out, right?
That
Uh,
would be my question for sure. How many innings is it again?
When is last call? When can I get my next drink?
Exactly. Well, speaking of getting drinks and, last call, it is officially 5, so it's officially after hours. So I'm
Woohoo.
woo, and it's such a beautiful day. We should be doing this on a patio. That
100%. I like that.
So, welcome everyone. This week we're talking about modifying child support and spousal support orders. Just a quick little bit of housekeeping. We don't have a chat feature, but we do have a Q&A for our Zoom attendees. So if you have any questions, any comments, please feel free to submit your feedback there. As a general reminder, the purpose of the series is to discuss general information on separation, divorce, and other family law matter topics. So any information provided here should not be interpreted as legal advice. If you do have questions regarding your specific matter, please call our office or a law office in your area to book a consultation to receive tailored advice for you. Also, stay tuned to the end. We will share a little teaser on how to get a free 20-minute call with one of our lawyers. So make sure to stay for that. On to introductions. For those of you who don't know me, I've been with the firm since 2018 and I just had my 6-year anniversary. I was called to the Bar of Ontario in 2022 and I am now an associate lawyer at the firm. I completed my undergraduate degree at Queen's University and obtained my law degree from the University of Liverpool in 2020, graduating with first class honors. And I'm committed to assisting clients through what is traditionally a difficult time by approaching matters with empathy, integrity, and compassion. On our screen, we also have Shanza. She's a recent law graduate from Osgoode Hall Law School and is an articling student with our firm, with plans to be called to the bar in Ontario in June of 2024, rapidly approaching. So her valuable experience stems from active participation in legal clinics, mooting competitions, and prior work as a legal assistant. She's focused on launching her legal career in family law, and she's dedicated to providing empathetic and proficient legal support for those navigating family-related complexities. And we have Russell. Russell is the founder and senior partner at Russell Alexander Collaborative Family Lawyers. That's a Bill move.
I know. I'm learning the best from the best.
One of the other associates in our firm, Bill Rogers, he's just such a joy and character. He's always doing
We love you, Bill, wherever you are tonight.
Yeah, so for Russ, with over 25 years of experience, he uses his knowledge and expertise to serve his clients in all aspects of family law. He's written 4 books and is a fully trained collaborative practice lawyer. And Russell speaks at conferences on collaborative practice, marketing, technology, and the law. So, without further ado, I will jump right into our topics for today. And Shanza, I'm going to ask you to
This is a great topic. You know, we get a lot of questions about this topic every week, so it's kind of nice we can dedicate a whole hour to it.
Yeah, absolutely. And I'm going to flip it over to you, Shanza, to get us started with understanding the current framework. So, how do support orders get determined, and what are some factors that are involved?
Yeah, thanks, Steph. So I'll talk about both child support and spousal support. I'll start with child support. So for child support in Ontario, we have something called the Federal Child Support Guidelines. And they basically guide how child support is calculated. It is a mathematical calculation. In Ontario, we have a table child support system, and the table basically determines the monthly child support payments for the payor spouse, and it is based on the income and the number of children that the parent is responsible for supporting. This table is the starting point for determining the monthly child support payment, so you can refer to the table. If your income, for example, is more than $150,000, then the court may depart from that amount. So that's the basic amount that you start with. And then in addition, there is 7 expenses, and these are the special and extraordinary expenses, and these are things that are paid for in addition to the table amount, and it includes things like extracurriculars, daycare expenses, post-secondary education, any health-related expenses. So that's basically the 2 guiding principles for what your child support amount could be. How much income each parent earns can itself be a huge exercise on its own. If a parent is not a salaried employee, if they're self-employed, for example, or they own their own business, or there are concerns with imputing income, then determining how much they earn could be a whole exercise on its own, and that'll impact the support payments, both child and spousal. For spousal support, on the other hand, we have the Spousal Support Advisory Guidelines, also called SAG. These guidelines, unlike the child support guidelines, they don't provide a definitive number, but they do provide a range. And then we have factors that come in that you can take into account to determine where you might land on the range. But before we go into the amount, first, you do have to prove entitlement. There are compensatory and non-compensatory basis for support. We had a whole session on it where we kind of went into some in-depth conversations on all of this. But basically, for the amount of support, there are 2 basic formulas that determine the spousal support. There's a with-child formula and a without-child formula. The with-child formula basically considers any support that's payable in addition to the child support. The amount will rely on the length of the relationship, the differences in income of both spouses to determine the range. If you have children, then that will impact the obligations and the amount as well. And then once you have a range using the formulas, then different factors come in, like financial means and needs, the roles that each person had during the relationship, ages of children, needs, ongoing responsibilities, all of that will come in and kind of impact how strong the spousal support claim is and the amount of spousal support that the parent will be eligible for. Okay, that's kind of my little overview on amount.
We can spend an hour on this. That was great, Shanza. Even on compensatory and non-compensatory, in simple terms, it's the role the person played during the course of a relationship, which may give rise to a type of support. But that was great.
Yeah, absolutely. And something that comes up often, especially when we're talking about modifying these support orders, is life changes.
Mhm.
Significant life events can cause changes in support orders. And, Russ, how can you navigate those types of situations?
Yeah, this is sort of a recurring theme that we're going to talk about tonight, but I'm just going to use some examples to illustrate what lawyers do. So little Johnny, right? Your child's done school, high school, and it's over 18. That's usually the trigger. But the order is silent. Perhaps the order or the agreement was drafted at the courthouse and it says, okay, hypothetically, dad's going to pay mom X amount of support. And we're going to adjust it each year, and that's it, right? It doesn't say it ends. But little Johnny's not in school. So we often get called in when mom, the other parent, doesn't consent to the change and wants to continue to collect the support. And we're going to talk about that. That's a difficult situation, but that's a life change that may necessitate is change for support. The child is no longer entitled to support pursuant, or the parent is no longer entitled to support for that child pursuant to the guidelines. Then we have what I like to call the professional student. They've got their first degree, they're not ready to enter the workforce, they get a second degree. Maybe they're having a great time at university, they're going to go for a third degree. When does it end, right? After how many degrees is the parental obligation to support this child end? Sometimes it's tied to the parents, right? If the parents are professionals and have a professional license like a medical degree, maybe there's an expectation you're on the hook for 7-8 years in university, maybe not. So that's another scenario where there's a life change and it's going to affect support. The victory lap. So little Johnny's in grade 12, he's 18, but he's going to go on to college, but he wants to take a year off to travel to Europe or maybe do another year of grade 12. We used to have grade 13 back in the day. And he or she's just not ready to enter, the workforce or has an offer for college or university and wants to wait a year. So now we have a gap, right? Oftentimes the judges will say support's going to continue if there's an intention to return to school. That's a life change, though, right? The other thing I want to talk about is Shanza did a great job. Just assume that the parent's income forms this pie. And we're going to slice up this pie. Some of it we're going to call child support. Some of it we're going to call spousal support. Generally speaking, long relationships, we want to go 50-50, maybe 52-48. That's how we're going to share support. So let's say little Johnny's done school and child support ends, and your court order or separation agreement says it ends. Well, that may increase your obligation to pay spousal support. You're paying $1,000 for child support, $1,000 for spousal support. Child support ends. There could be a claim that spousal support should now go up to $2,000 or maybe $2,400 with the tax adjustment. So that's another change. Retirement, right? Big life change. The test is material change of circumstance. So most people can anticipate they're going to retire when they entered into their separation agreement or court order. So there's an argument to be made that this is not a material change of circumstance. You knew that when you entered into this order, and you're going to be obligated to pay. The flip side of that is that support pair may have already divided their pension through property division. Now we're looking at a double dip, meaning you can't collect support twice from the same source. Another life event that's going to inform, your entitlement to child or spousal support. One last point, and we're just giving you a flavor just to illustrate how your support order can be changed by different circumstances. Okay, so little Johnny goes and visits with dad for his summer access, right? That is pretty good. Dad doesn't want to go back. Maybe he's 14 or 15, says, I'm going to stay with dad. Now we have a change, right? Dad might be paying child support for little Johnny, but now little Johnny's living with him. So maybe dad's partner or a former wife now has an obligation to pay him support. This happens all the time. Steph will tell you every September we get these these cases where somebody doesn't want to return the child, or the child doesn't want to return, or you can imagine the circumstances. Oftentimes it's just a bump in the road, but this is a circumstance that can change support order. And then ideally you're going to agree with your spouse in terms of how that change is going to look. More often than not, we're called in to get things sorted because it can be complicated. And we're often dealing with court orders and family responsibility office that does enforcement. So it's something to consider.
Yeah, absolutely. And the list, there's no hard and fast rule when it comes to what's a life-changing event. It's, it could be anything from income fluctuation to loss of job to illness to change in parenting time. But all of
Full
those
disclosure, little Johnny's not a client of mine. It's a fictional, doesn't exist. I'm just using him as an example.
We need that blurb at the start of movies that, it's not an accurate representation. It's not
That's right.
a true story. But absolutely. And I think something that, or a term that often comes up when I have conversations with clients about support is this idea of fairness.
Mm-hmm.
Well, it's not fair, or, how do we make sure it's equitable or equal? So as Shanza did a great job in laying out the framework on how support is discovered, right? And how it's determined. So for table child support, we're looking at the income of the parties, the number of children, where those children are living. When we're looking at Section 7 expenses, or these special expenses, we also have to think about, is it a Section 7 expense? Does it fall outside of that definition? And the courts, when looking at that, say, is this expense necessary in relation to the child's best interest? And is it reasonable? Is the expense reasonable in relation to the means of the spouses and that, the needs of the child? So if taking little Johnny, prior to separation, little Johnny's not not in hockey, not in gymnastics, not in anything like that. And then post separation, one spouse wants to enroll little Johnny in all of the extracurriculars. Maybe they're the support recipient and they want little Johnny in, he's going to be the next Marner. He's going to be, making it big, and wants to, enroll little Johnny in all of the extracurriculars. Well, from the support payors perspective, we also have to look at if that's even feasible. Can this person, in addition to the child support, the monthly child support obligation, can they afford to cover these Section 7 expenses? So the courts do have these tools and these, ways of determining what's a reasonable expense and what's not. Another conversation that often comes up is, like Shanza mentioned, income, right? If you're not a T4 employee, or your spouse thinks you're either purposely underemployed or purposely unemployed, that can be an extremely big hurdle to overcome, right? So there's a lot of things that can be done with respect to determining income, or an accurate determination of income, to better balance the scales. And it could be either way. It could be the support payor is purposely underemployed to sort of shy away from their obligations, or a support recipient is purposely underemployed or unemployed to get a bigger piece of the pie, as Russ mentioned. So ultimately, when support is determined, and also when support is being modified, all of these things are taken into account. And like Russ said, child support takes priority. Then we look at Section 7 expenses, and then we look at spousal support. So that's also sometimes a very hard pill to swallow when the support recipient is getting child support, but there's no more room for spousal pay. So it's a very, very delicate balance, and there's a lot of factors and things to be mindful of and to consider, which is, of course, always why we would recommend that you speak to somebody, speak to a legal professional, a family law lawyer in your area, because there's just so many elements. And like Russ said, we could do an hour on each separate point that we're going to talk about today. This is just a flavor of things to consider. So
we have more resources and videos on each one of these topics, but and we'll try to include those in the links in the follow-up email after tonight's event.
absolutely. And another thing to be mindful of is what the legal standards and what the legal criteria are that courts apply. I talked a little bit about it, but Shanza, do you mind going into a bit more detail?
Yeah, so once you have a change in circumstances, like Russ and Steffi just gave examples of what these could look like. So what do you do next is you can go to court for a variation order. The court process for a variation order is a motion to change. And when you bring this motion, you can ask to change or end a family court order if you have one, or change or end an agreement to pay support if what you were working off was a separation agreement. Obviously, your order can also be changed on consent of both parties. And if that's the case, then the motion to change it will not be necessary, and then you don't really have to go to court. You can settle that outside of court. But if it is contested and you are in court, then the party that is seeking to change the initial order will have to prove that there has been a material change in circumstances. And Russ kind of talked about that a little bit early on. The key word here is material change. That's the legal test that you have to meet. And for something to be considered a material change in a court order, it has to be something that wasn't there, it wasn't known, or it wasn't true at the time of the original order. It also has to be something that would have made a difference in the original order if those circumstances had been known back then. So not every change will justify a change in the order. Sometimes, as Russ mentioned before, anticipated changes, for example, retirement, are already considered by the judge in the original order, and so those won't really justify a change in the order if and when those events do occur. So that's the requirement that the change has to be unforeseeable. If it's already accounted for, it's unlikely that it will justify a change in the order. And that's essentially what we're trying to prove in front of the judge when we say that there has been a material change. So if you are in the spousal support realm, the guidelines, the SAG that I mentioned, they do provide some useful comments on various material changes that may allow a variation or termination of spousal support. You can take a look at those. They describe things like Steph mentioned it, income changes. That's obviously one of the more obvious reasons to change the to support order. But it also goes into situations like voluntary underemployment. Russ talked about a little bit as well. The court will ensure that the change in income isn't voluntary or intentional to misguide the court. There are safeguards in place, remarriage, retirement, all of these can result in a variation. And for child support, the most common change is the parent's income, which will result in the amount of support being adjusted to the table amount applicable for that new income. And other circumstances could be things like if there is an increase in the cost of the parent's parenting time with the child, that could justify a variation order. Or if the child finishes post-secondary degree, that could initiate a change in the support. Or if mid parenting arrangement, you change it. You change to a different parenting arrangement. You go from 20/70 to 50/50. If you go to shared, all of that can trigger a change. And those are reasons that you could find yourself in court to get a variation order.
Yeah.
Shanza, how often do you change child support? What's the norm?
Well, it depends on the material change.
No, I mean, like, do you do an annual review when the income changes?
Oh,
How's
yes. So you do. So every year you do want to provide financial disclosure, and that kind of lets you know what the income is for every year. And then based on your disclosure, the child support amount is determined every year.
And the disclosure would be what, a tax return or something?
Your tax return, if you're a salaried employee, you want your line 150 income. If you own a business or you're self-employed, then that's when your business records will come in, and then that will be used to determine your income.
Yeah, and actually a question just came in. So what happens if you don't disclose your income, or if your ex doesn't supply their notices of assessment or their income tax returns? What happens then?
I think you should ask for it in writing, because if they don't produce it and you ask a court to make an order because the income's gone up, and you can show your email or however you put them on notice, I asked for it way back when, the judge is going to do a retroactive adjustment. Another question came in, what about equal parenting time? And who pays child support then? There could still be a child support order. There could be a set-off. One parent may have a greater income. So we would look at the two guideline amounts, set the two off, and the one with the higher income would then top them up. And if you have an existing order for shared parenting or 50-50 and one parent's not following it, you should ask a court to enforce that order.
Absolutely. The courts do not, at least in my experience, they do not like self-help behavior. So if you have a court order that says the child is supposed to be with you shared, or, shared, just a reminder, it's 40-60 also is considered shared parenting. So if you have a court order that says that the child's supposed to be in your care equally or in a shared arrangement, and one parent is withholding the child to say, well, no, I'm actually the primary parent, so you need to pay me more support, that's a self-help measure, and that's extremely frowned against or frowned upon. So definitely do not be taking those types of steps.
The judge will actually look at you and have a frown on his or her face. But these are great questions. Keep them coming in. Thank you so much to our audience for participating tonight.
Absolutely. And what are some other challenges or some other limitations? So we have the issue of disclosure, not providing disclosure. What are some other common hurdles faced when seeking modifications, Russ?
Well, when a client comes into my office, staff, the first thing I want to do is read the court order, the agreement. What does the agreement say? A properly drafted agreement will have a mechanism to deal with changes and limitations. So look at the order. You'd be surprised how many people rush off to court and don't even read what the underlying agreement could be several years old, sometimes 15, 20 years old. You need to find that document and read it. Oftentimes, there'll be a dispute resolution provision built into your separation agreement, or a mechanism built into your court order. It may say you're to produce and exchange your notice of assessment, your income tax return, a current pay stub, and adjust by June 15th each year, retroactively or prospectively, depending on what you've agreed to. Dispute resolution clauses often have a provision for exchanging information, and it could send you off to mediation, arbitration, back to your collaborative lawyers if you use the collaborative process. Oftentimes, there's a limitation before you can run off to court to explore the mediation process. And I've seen this more frequently, Shanza, than I would like to say. Somebody's at a case conference. The judge looks at the materials. They'll say, did you try mediation? The answer is no. Did you notify the other parent of the changes you want to make? Usually the answer is no. And they get kicked out of court. They say, go try the mediation and come back on another court date. I'm not going to, because that's what you've agreed to. So you can't blame the judge who has limited judicial resources and time to produce and adjudicate an answer when you haven't even followed the language that you've agreed to. So mediation first. Almost always the Divorce Act provides for parents to explore family dispute resolution prior to going to court, and is strongly encouraged by Superior Court justices who operate case management in the Unified Family Court here in Ontario. The system is slow. So let's just say you've done the mediation. Now you got to go to court to do a variation because little Johnny's out of school and you need to change your support. Could be 18 months to 2 years before you have a hearing. Want to provide the other side with notice, supporting documentation for the change. I would even recommend produce an offer to settle. So if you calculate the retroactive support for little Johnny to be hypothetically 25 grand that you've overpaid because the other parent didn't agree to end support, maybe I'd offer to adjust it at 20. I know I'm gonna have to pay my lawyer a few $1,000 and I'm gonna have to wait 18 months. Take a discount, get it resolved, save your money, move on. More importantly, if your offer to settle is not accepted and you do go to that hearing and you get your $25,000, you can say to the court, I offered to resolve the child support issue at 20. The other parent didn't take it. I want my legal fees now paid for by the other parent. And oftentimes you'll get that. So really effective tool strategically to deploy. If the offer is accepted, then you get the matter resolved and you don't have to worry about any more sleepless nights. The Family Responsibility Office, unfortunately, is not going to help you. You call them up or you go to the office. I don't think they have an office you can access, but if you go to court and there's a representative of the Family Responsibility Office there and say, here's my order. I shouldn't be paying support for little Johnny anymore. They don't have the authority to change it. They're not an adjudication service. There's been some talk about changing the legislation to allow the Family Responsibility Office to do summarily adjudicate simple child support matters. Right now, you're going to need a court order to change it. Having said that, if it's urgent, let's say you're going to lose your driver's license because it's going to be suspended for unpaid child support, you can bring a motion to what we call refrain the Family Responsibility Office from taking certain action, including suspending your driver's license. You'll probably have to enter into a payment plan, very tight deadlines to bring those types of motions, but there is it's not a final resolution, but a judge can make a temporary order to perhaps, even if it's obvious that support isn't being paid, perhaps suspend support until there's been a hearing. But those are some of the things you want to consider. If you do, if you're underpaid or overpaying, you certainly want to look at a retroactive adjustment and to get some of that money back and some of your legal fees as well.
Absolutely. So we just have a few questions coming in. Keep sending them in. We're going to do our best to get to as many as we possibly can. So what about the hurdle of an order stating an end date for child support, but not an end date for spousal support?
Right.
I guess the question will depend if you're the support recipient or the support payor. More often than not, it's the payor who would want to adjust or vary the order to terminate support. But Russ, go ahead. What's your take?
You want to put a lot of meat and potatoes in the underlying document. So if you're entering into an order like that, you want to tell the court what the assumptions were, right? The spousal support guideline, the SAGs, the spousal support advisor guidelines maybe said support is for a duration of 7 to 10 years. And we chose the mid-range calculation based on a number of factors and set that out. It's going to be easier for a court later on to say, okay, the termination is ready to go. Or even put an end date in your support order. Sometimes the recipient's need could increase and your support obligation could increase, especially if increases in your income is tied to the role that your spouse played during the course of the relationship. So there's so many factors. Length of the relationship, ages of the parties, their incomes, their budgets, whether somebody suffers a disability or not, their ability to re-enter the workforce, imputing income to the recipient spouse. Perhaps the recipient spouse is repartnered and has a new spouse with an income. That could be a triggering event as well. So there's so many factors right now. I can't give you a specific answer to that question, but these are things you want to start thinking about. Great question.
Absolutely. Another question that came in is with respect to the child tax benefits. So if the parties have 50-50 or a shared parenting arrangement, but one parent is the only one claiming the child tax benefit, what are some options there? Is there a way to apply to the CRA to divide the child tax benefits?
Well, I consider, if you're a higher income earner, you may not qualify for the benefit. This gets heated, right? People get upset about this tax benefit. It could be a significant amount of money too. If the parent's supposed to have a decent income, maybe you flip the tax benefit into an RESP for the child to use when he or she goes to college or university. Lots of creative solutions. Do not spend money on lawyers arguing over the tax benefit. And I tell my clients, sometimes my clients want to make a change. They want to seek increased parenting time. So don't make the argument for the tax benefit or child support reduction. It's going to look like you have improper motives. Continue to pay it. Enjoy the extra time with your children. Lots of different ways you can approach it. What would you do, Steph?
Yeah, so more commonly, especially if I'm in the, negotiations, alternative dispute resolution method, uh, split the child tax 50-50. You can apply to the CRA to divide it accordingly. You can let them know that the child is with you 50% of the time, with the other parent 50% of the time, and then the government will do the rest for you. So you don't have to exchange money with the other parent. It goes right from the source. So that's more often my recommendation, because then it sort of washes, it takes the parties out of the equation and leaves it up to the government.
Yeah.
Yeah. So another question that came in, I'll just open floor, or maybe I'll just take it. So for those of you who are commencing a motion to change, who are self-represented or you don't have a lawyer right now, any issuing document, whether it's a court application or a motion to change, pursuant to the family law rules, those have to be served personally. In the movies where there's a personal process server that goes, "You've been served." Not as glamorous, but that process has to happen. That exchange has to happen. So if you don't have somebody to do that for you, you can always look into what's called a process server. You can Google process servers in your area. They might charge a fee, but you would provide them with the name, address, when they might be home, perhaps a work address, and they'd be able to serve those documents for you.
And if they're evading service, you can get an order for substituted service, perhaps on their employer or their mother or somebody that you can provide some evidence that they would receive the information.
Absolutely. And moving away, so that's for a court application or a motion to change. But if you're in
There's a great question about retroactive support and how far you can go. I want you to think about a few things. If it's court order, go back to the date of the court order. I would go back, 15 years if I could. But you need to provide some explanation as to why you didn't bring it back sooner. Especially if you've been getting the up-to-date notices of assessment and tax returns. So you want, there's lots of case law on this from the Supreme Court, but going back, we used to talk about blameworthy conduct and generally a 3-year rule. I think if there's no order, the court would probably go back 3 years, 1 to 3 years, depending on the circumstances. Not likely much further than that. It depends on the circumstances and the incomes, but it's a great question. And it's a difficult one because you expect people to comply with court orders. Not everybody has the resources to take it to court right away for enforcement.
Absolutely. And that sort of ties back into your point earlier, Russ, about putting it in writing. Ask for that review, ask for that annual review. So that if you do go to court a few years down the road, you can show the court, look, I did ask, but I'm only able to get to court now.
And parenting time or access is unrelated to child support. So you still pay your child support whether or not you're seeing the child. So that's an important distinction. There's a question that came in along that vein, but I just wanted to raise that.
Absolutely. And if you're not in court yet, or you want to pull out of court and look at some alternative dispute resolution options. Shanza, what are some effective methods or ways people can utilize mediation, collaborative process to deal with these modifications of orders?
Yeah, I'll start by saying that we talk about ADR quite a bit, but it can be just as effective, in the context of modification disputes, what we're talking about today, if not more. By not going to court, you're saving money, energy, time, stress. I think ADR is well suited for support modification because when modifications are sought, often the issues include financial changes of circumstances and the like. Asking for that annual review. And these issues can be easier to address because the issues are usually more focused and narrowed, so it's easier to kind of enter into a dialogue and try to come up with solutions. Because often when you're asking for modification, other interrelated issues are previously settled. So there's less issues to deal with, which makes ADR more likely to be effective and successful. It's different than going to ADR when there is no settlement on anything. Russ mentioned mediation, there's negotiation through lawyers, there's arbitration, there's collaborative law. So when you're going through these processes, instead of going to court, you're working with a neutral third party, or in the case of collaborative, you're working with a team of professionals, and they kind of help you negotiate and they guide you towards a mutual solution. If you're in mediation, family mediators, they will guide the process and they can help you negotiate in an environment that is more controlled, it's less stressful. There's also arbitration. Arbitration gives very similar benefits to mediation. It's different from mediation because the arbitrator's decision can be legally binding, but it can still be faster than going to court and litigating. In arbitration, you also have more say in how the proceedings are run. And I think a great thing about ADR is that it really facilitates communication, and it's really focused on finding solutions. And if you have children and you're dealing with child support and you're co-parenting, being in mediation, being in ADR, it really provides that foundation to the parents to be able to effectively co-parent and to continue to co-parent without adding any extra conflict. If you can settle, that is obviously encouraged, but there are cases where there's power imbalances and the court's the right avenue. But if the conflict is manageable, then ADR should always be an option, and it should definitely be attempted in good faith.
Absolutely. And it sort of ties back into this. So everyone here on your screen is collaboratively trained. And another alternative dispute resolution method is collaborative process. And it's something that I always recommend parties consider, especially when they're, amicable and fairly aligned in a sense. But the benefit of this collaborative process are financial neutrals. So, we mentioned this annual review of child support, spousal support. So that's when you're exchanging your disclosure each year and adjusting the calculations. Well, instead of the two of you going back to your lawyers to make sure the numbers are correct and everything's on the up and up, if you're in the collaborative process, you have a jointly retained financial professional. And rather than the two of you paying your lawyers to do the calculations for you, to double check and say, yes, this is the new amount, you can each go to the jointly retained financial professional and they'll be able to do the calculation for you, let you know, so that you can make sure you're on the right page and you're paying the right number, the right value. The other benefit that I often see with these financial neutrals is budgeting. You're used to being one household with dual incomes flowing through, and now you have to adjust to not having that extra income coming in, or you're limited to a certain support value. So these financial neutrals are a great resource to help you budget, adjust accordingly. Maybe you have a goal that you want to save even more for retirement. Maybe you don't. Maybe you're loving life. You want to go on trips. You don't need to save. But these financial professionals are great resources that can really stem from the collaborative process. They already know you. They know your finances. They know your support payments, your support obligations. So those are definitely people I would always recommend. Even if you're not in the collaborative setting and you want to connect with one of these professionals, it's always a great option and a great tool. All right, so I'm gonna jump to some Q&A. Keep them coming in, everyone. Keep them coming in. So we have a question here. As a spousal support payor, why is remarrying a negative factor if you file separate tax returns?
Yeah, I think you may not have understood my earlier comment. If you're a recipient and you remarry, that affects your budget and your need for support. Mind you, if you're a payer and you remarry, your new spouse, in my view, his or her income's not going to be helpful. It might make it easier for you to pay support if you're dividing expenses with them, but I would be more focused on the recipient spouse. And oftentimes, separation agreements will put in language saying remarriage could be a material change in circumstances, or living in a state of cohabitation for 3 years could trigger a review, or the agreement might even say that support terminates.
Absolutely. But on that note, for child support, so say I'm paying child support to Shanza. We have little Johnny. But Shanza remarries. Just because Shanza remarried and she now has another partner, my child support obligation to little Johnny doesn't end just because she now has a partner with more income in that household, because my obligation would be to the child, not to Shanza. So also important to bear in mind.
Unless there's a hardship argument and you do a continual analysis, then you need household budgets, but that's for a different topic.
That could be absolutely.
That's the 9 p.m. after hours show. That's the extended one. Steph's gonna be in bed by then, so.
Absolutely. All right, so we also have a question come in here about long-term spousal support payor, lost their job, now retired. So those are some things that in my mind trigger a material change in circumstance. But for a specific question,
not having an income, yeah, that would be a mistake.
Yeah.
You can't pay support if you don't have a job. Unless income's been imputed to you.
Exactly. So, but Russ, what happens if the ex-spouse lives here in Ontario, but the support payor has now moved to BC or to Alberta or a different province? Where should that person bring a motion to change the order?
Yeah, ideally you'd bring it in Ontario where the recipient spouse is, but you've got interjurisdictional enforcement orders now. So I've had cases in Ontario where we have a hearing here. The other spouse is in Quebec. The court produces a transcript and is sent to Quebec to have it confirmed by a superior court sitting in Quebec. So, and that's similar for the US and Canada as well. The jurisdictions can cooperate and do an interjurisdictional support hearing and a variation.
Absolutely. But one thing, so with that interjurisdictional component, it's also important to bear in mind when you're doing the support calculations, whether you're using DivorceMate or an online calculator, where the support payor lives, that needs to be noted because sometimes that can impact the numbers. So just make sure if you're living in BC and you're paying support, or you're living in New Brunswick or wherever you are, that the support calculations are based off of where you are residing. So we've talked about some stories. We always love a good story time. Do you have any stories for us today, Russ? Some real life scenarios that navigate complexities? This could be.
To have stories I was told earlier this morning, I shouldn't be reliving these stories. It's not good for my my stress levels. So let's just talk about some samples that we see all the time. right? Every busy family lawyer will come across these cases. So probably the most common one is the uncooperative other parent. Clearly there should be a change. They're not going to cooperate. They're going to sit on their hands. They want the income coming in, or maybe they want to exact some retribution for perceived wrong that they felt occurred during the marriage or the court case, and they're simply not going to cooperate, which is unfortunate because then we need to engage the court. We need to use judicial resources. It's going to take time. Somebody's usually going to pay the other person's legal bill if they're successful. So that's something we see. Litigation is often, or almost, with this uncooperative parent, litigation is required to get the family responsibility office sorted. So if there's enforcement, if there's a garnishment, if there's an order that's being enforced through the provincial agency, we need a new order directing the family responsibility office to either stop or change it based on what the proper amount would be. We talked about refraining motions to bring motions to limit or suspend the enforcement proceedings. That's quite common. Usually we get the client coming in a few days before the hearing and they're jammed up, right? They're going to lose their driver's license, they're going to lose their job, but they have to get it done. And oftentimes we have to drop everything to try to get the information properly before the court, which means preparing court documents, serving, filing, attending court sometimes in person or through Zoom. And that could all take time. The longer you wait, it's usually the more expensive it's going to be for your lawyer to react, because we're doing additional work in a quick period of time and we're charging by the hour. So if you contact your lawyer as soon as you get that notice from the family responsibility office, we often have times to negotiate a payment plan and come to a resolution that can simply be filed with the court. We talked about this consistently. The court will quite often do a retroactive adjustment and order costs for somebody who's acting improperly or delaying the proceeding. That's something we see quite often. And also we're seeing increased claims for support for adult children. Seems to be more common post-pandemic. We have a changing job market. We have a bit of a housing crisis in terms of what it costs to live in Southern Ontario. More children are living at home longer, or can't secure their own housing, or going to school for longer periods of time. So we're seeing that support order that would traditionally end at 18, or perhaps after the first post-secondary degree or diploma, being extended. Maybe little Johnny didn't like his course and changed programs midpoint, or maybe the marks were bad and they had to go from a university setting to a college setting. So this seems to be quite common and more prevalent. So these are scenarios that we see common, frequently, everyday scenarios that families are facing, and that's what I'm seeing at least. Shanza, what are you seeing on your end? I know you're an articling student, but you've been through the trenches now.
Yeah, no, for sure. I think it also kind of goes back to what I was talking about, material change. I was just helping, and this also ties to one of the questions we have about a recipient going back to school. Just recently, I was helping David, my principal, on a case, and this is where the support recipient kind of went back to school. And there were concerns as to should any income be imputed, because technically this person was working. And I think on a brief on a brief overview, one would think that because someone is working and then out of the blue, they quit their job and now they're back to school, then some income should be imputed. But it turned out that there were settlement negotiations, and it was anticipated that they were planning on going back to school. And so it really can be very circumstantial and really differ from case to case as to what is a material change, what is not a material change. On first instance, one would think that, this is not a material change. There should be in this case that I just mentioned, there should be income imputed. But there are always circumstances, and you kind of want to look at the whole picture and see where the parties are coming from to kind of really know what's applicable in a specific case.
Yeah, absolutely. I think just highlighting the fact that it is very much a case by case analysis is super important. Yes, we had the child support guidelines, which are guidelines. The courts follow them. There's specific amounts. There's always exceptions. There's always it depends. There's always rules and nuances that could apply. What happens if your income is over 300,000 a year? Then the support guidelines don't necessarily apply in the same sense. There could be further support obligations after that point. And then when it comes to spousal support, it's a range, and there's all these factors that the courts will consider. So if you're, a range, do I fall low, mid, high? How long is it going to last? Is it indefinite? What does indefinite mean? It doesn't mean forever, by the way. It just means for an undefined amount of time. The legislation is very funny that way. They make it sound like it's permanent, but it doesn't necessarily mean it is.
Mhm.
So
There's lots of discretion built into it,
yeah,
right? Some factors the judge may weigh on heavily, another judge may consider not as helpful. So a lot of it would depend on what judge you draw, especially for a spousal support claim. Child support's a little bit more clear cut. The post-secondary expenses have a bit of gray area in it, but you never know. Like you said, Steph, it depends.
it always depends. And this topic of undue hardship can come up. The payor's ability to pay. So if questions come in, I'll just sort of open it up to the floor. What happens if the support recipient was receiving child support, spousal support, or some other, the child tax benefits, and with those amounts they were approved for a mortgage or a loan or something to that effect, but a material change in circumstances has occurred, and now they can no longer afford it because they're not getting as much support. What happens there? Does that recipient claim undue hardship?
Yeah. 50-50 parenting doesn't mean an automatic adjustment to child support. You can have shared parenting and still pay the full guideline amount. The tax credit is a different story. Undue hardship arguments are super difficult to make. If you're making over $25,000, I don't think a court's going to find undue hardship, unfortunately. And I know interest rates have gone up and mortgages are very difficult to manage these days. But I would want to know if the other parent is maximizing his or her income, if they're being intentionally underemployed, if they went to 50-50 parenting for support reasons, which may give the judge some discretion to say, I'm still going to order the full table amount.
Yeah. And another, conversation that I often have with clients is this fear of, you put in your income and your ex's income and how many kids you have and where the kids are living. And this table child support amount is just baffling, and you don't think you can afford that table child support amount. And that's when we look at what's called a financial statement. It's a Form 13 if you want to take a look online. The Ontario courts forms have it. And in these financial statements that get submitted to the court, there's a budget, right? Like, how much are you paying in rent or a mortgage? Do you have significant debts that you're catching up on? What are your utilities like? All of these things. And based upon your annual income and your yearly expenses, it shows what you're sort of left with. So the courts do take that into consideration. I think, like Russ said, these undue hardship claims can be very, very difficult. But if you have a valid claim, like absolutely, definitely call a lawyer, speak to somebody. Our best practices and recommendations are to really, look to your current order or agreement. Is there a varying condition or a terminating event? Are there details in your order agreement that specify what's a material change? But ultimately, if you don't know, if you're unsure, you want some guidance, reach out to a family law lawyer. Our office is open. You can give us a call, give a lawyer in your area a call, and definitely get tailored independent legal advice for your situation and your circumstance. All right. So, does anyone else have any other takeaways or anything else that we want to share? I know we've had a lot.
I know you've got a court hearing at 6, so
I
you have
do.
a teaser. You have a teaser that you want to talk
We're
about.
keeping our audience waiting. They're waiting
And
for
I can
something.
say operators are on standby right now. So I asked my intake team to stay open late because we were doing this event. But what's the teaser, Steph? What do we need to know?
Absolutely. So I just want to thank everybody for sticking around until the end. I did mention a little, opportunity to get a complimentary 20-minute meeting with one of our lawyers. So to take advantage of that, make sure to register by noon this Friday by emailing Nicole at our intake department at nicole@russellalexander.com. And what's the code for today? Russ, ball's in your court.
Why don't we say Nicole 2024? And I think the phone lines are still open. So if you mention that over the phone, you could probably secure your spot. But if you don't book it by Friday, all those spots are going to fill up. Doesn't mean you have your appointment by Friday, but you want to get it booked by Friday. And you can find the phone number on our main office number. Call one of our offices and you'll be connected to our intake team.
Absolutely. So I've just put it in the chat. So make sure to take advantage of that by noon this Friday. Thank you again for everybody who joined us today, who submitted your questions. We absolutely love getting these rapid fire questions coming in. So following the session, a brief survey will appear. If you feel free to share your comments, suggestions for future topics, things that you like us to talk about, want us to explore more. Your feedback is always greatly appreciated. And we're going to end it there. We're a minute early today.
The Form 13 is the financial statement form used in the Superior Court of Justice for Ontario. So it's a financial statement. Search online, you'll find it. But great job, Steph. Shanza, great job tonight. We got to get you going. So I want to thank our audience for joining us tonight. That was a lot of fun. Great questions tonight.
Thanks, everyone. Take care.